You just sent an email from your work account. Maybe it was to a friend. Maybe it was to a recruiter. Maybe it was something personal you didn't think twice about. Here's the question nobody asks until it's too late. Can your employer actually read that? The answer is not what most people think. And the line between what's legal and what's a federal violation is thinner than your company's IT policy makes it sound. Over the course of this video, I'm going to tell you exactly what your employer can and cannot legally monitor on your work email, your personal email, your texts, and your devices, because the rules are different depending on which one, and most employees have it completely backwards. I'm a lawyer. I've counseled employees and employers on both sides of this issue, and I can tell you that most employees are either overly paranoid or dangerously underinformed about where the legal lines actually are. Let me show you how to think about this correctly. When I look at an employee monitoring question, I ask three things. Get these right and you'll know exactly where you stand. Question 1. Whose device is it? Your employer's laptop or phone? Or yours? This is the single most important variable in this entire analysis. It changes almost everything. Question 2. Whose account or network is it? Your work email on your company servers or your Gmail on your personal hotspot? Again, completely different legal landscape. Question 3. Did you consent? Did you sign an employee handbook, an acceptable use policy, or an onboarding document that included a monitoring disclosure? Because if you did, that signature changes what your employer can do. 3 questions: device, account, consent. Let's run through what each one means for your rights. First up, work devices versus personal devices, the critical distinction. Let's start with the most important rule in employee monitoring law. If you are using a device your employer owns, a work laptop, a company phone, a tablet issued by your job, your employer has very broad legal authority to monitor what you do on that device. Emails, text sent through company apps, browser history, keystrokes, files, all of it. The Electronic Communications Privacy Act, or the ECPA, allows employers to monitor communications on company-owned devices and networks as long as there is a legitimate business reason. And courts interpret legitimate business reason very broadly. Now, here's where most employees go wrong. They assume that if they use their personal Gmail or send a text from iMessage on their work phone, that data is somehow protected. It isn't. If it's on a company device or routed through a company network, well, then your employer may have access to it. On the other side of that line, your personal device, your personal iPhone, your home laptop, your tablet that you pay for. If you are using your own device on your own data connection, your employer generally cannot monitor your communications. The Stored Communications Act, known as the SCA, protects the privacy of electronic files and messages stored by third-party providers. That includes your personal Gmail, your personal text messages, and your iCloud. There is one exception worth knowing. If you connect your personal device to your employer's Wi-Fi network, your employer may be able to see your internet traffic on that network. Not the content of your messages, but the sites you visit, the apps you use, the volume of data. That is why using your personal hotspot at work on your personal phone is a meaningfully different situation than using the office Wi-Fi. 2 federal laws govern most of this. You don't need to memorize them, but you do need to understand what they actually do. The Electronic Communications Privacy Act, also known as the ECPA, is the primary federal law. It was passed in 1986, which means it was written before email was common and before smartphones existed. Courts have stretched it to cover modern technology, but it has significant gaps. Under the ECPA, employers can monitor electronic devices on company systems if they have a legitimate business purpose. The law also has a consent exception. If you consented to monitoring, which most employee handbooks get you to do on day one, then the employer's monitoring authority is substantially expanded. The Stored Communications Act, or the SCA, is the one that protects your personal accounts. It makes it illegal for anyone, including your employer, to intentionally access electronic communications stored by a third-party provider without authorization. This is the law that protects your Gmail, your personal texts, your iCloud messages. It's also the law that employers occasionally violate when they go too far, and those violations can result in federal civil liability. Here's the practical takeaway from both laws combined. Your work communications on company systems are not private. Your personal communications on personal accounts and devices are substantially protected. And your employer accessing them without authorization may be a federal violation. Regardless of device and regardless of consent, there are things your employer is never legally permitted to do. These are the hard lines. Your employer cannot access your personal email accounts, personal social media accounts, or personal text messages without your explicit authorization, even if they find access through a company device. The SCA protects these accounts because they are stored by a third party, not by your employer. A case called Benz versus PHB Realty settled after an employer accessed a personal email account found open on a work computer. That's a federal violation. Your employer cannot use monitoring software on your personal device without your explicit consent. If your company asks you to install a monitoring app on your personal phone, you have the right to refuse. And in many states, they cannot make it a condition of employment without disclosure. Your employer cannot monitor your communications for the purpose of interfering with protected union organizing activities. The National Labor Relations Act explicitly prohibits using surveillance to suppress union activity. If your employer is monitoring communications and using what they find to retaliate against employees discussing wages, working conditions, or union organizing, that is a separate federal violation on top of any privacy issue. And perhaps most importantly, your employer cannot access your personal accounts at the time of your termination to look for evidence against you. If you are fired and your manager logs into your personal Gmail through a saved password on a company device, that is potentially a federal crime under the SCA. Document it immediately if it happens. Federal law sets the floor. Several states have built extra protections on top of it, and if you live in one of them, your rights are meaningfully stronger. California has the strongest protections. The California Consumer Privacy Act gives employees the right to know what data their employer collects, and employers must disclose monitoring practices. California Labor Code Section 980 also prohibits employers from accessing employees' personal social media accounts. New York requires employers to notify employees in writing about electronic monitoring at the time of hiring and to post a visible notice. No notice, potentially no legal monitoring. Connecticut and Delaware both require advance written notice before employers can use monitoring software. Illinois requires written consent before collecting biometric data, and companies that violated this faced class action settlements in the hundreds of millions of dollars. If you're in one of these states, your baseline protections are significantly higher than the federal floor. Look up your state's specific statute. I've linked the resource in the description. Here's your action stack. 5 steps in order of priority. Step 1. Read your employee handbook right now. Find the acceptable use policy and the monitoring disclosure. What did you consent to? What devices does it cover? What communications? You need to know what you already agreed to before you can evaluate your situation. Step 2. Audit your device usage. If you have been using your work device for personal emails, personal browsing, or personal communications, stop today. Move all personal communications to your personal device on your personal data connection. Do not use company Wi-Fi for personal accounts. Step 3. Check your state's monitoring law. The rules are meaningfully different in California, New York, Connecticut, Delaware, and Illinois. I've linked the state-by-state reference in the description. If your employer is ever monitoring you without the required notice for your state, that may be actionable. If you want a template for a formal monitoring inquiry letter to HR, something that puts your employer on notice that you are aware of your rights, I've linked one in the description. Step 4. If you believe your personal accounts have been accessed by your employer without authorization, document everything immediately. Screenshot any evidence, note dates and times, and consult an employment attorney before taking any other action. A violation of the Stored Communications Act is a federal civil claim. It has real teeth. Step 5. If you are about to leave a job, voluntarily or otherwise, clear your personal accounts from any company devices before you hand them back. Log out of Gmail, iMessage, and all personal social media accounts. Removed any saved passwords. Do this before your last day, not after. One more time, here is your 5-step action stack. Step 1. Read your employee handbook. Find the monitoring disclosure. Step 2. Move all personal communications to your personal device and hotspot. Step 3. Check your state's specific monitoring law. Step 4. If personal accounts were accessed, document everything and consult an attorney. And Step 5. Before you leave any job, log out of all personal accounts on company devices. Before you go, I want to hear from you. Have you ever felt like your employer was reading your messages or monitoring your activity? Drop it in the comments. I read every one, and those real situations shape exactly what I will cover next. If this was useful, subscribe. New video every Tuesday. And if you want to understand another piece of your employment situation that most people get completely wrong, the next video is on at-will employment. Specifically, what it actually means, and maybe more importantly, what it doesn't. Because most employees think at-will means their employer can do anything. It doesn't. See you on Tuesday.